You've heard of 40 days and 40 nights, but have you ever heard of 40 motions filed in one day in the Karen Reed case? Plus, our viewers have some questions about the 911 and texts in the Coburger case.
"40 motions? That can't be real." I'm Lainey Law.
And I'm attorney Andrew Myers.
And what do you mean 40 plus motions?
I mean that in one day, March 11th of 2025, I just go in and check the docket, and 41 filings, motions, affidavits, and all the other good stuff. But that's a lot for one day. So with the pressure of the actual trial coming up, 41, if you don't believe me, voila, there they are. This is the docket sheet in the Karen Reed case for one day. And we'd be here till, midnight tomorrow if we went over all of them. There's a lot of them, but I highlighted and bolded the really important ones. A Commonwealth motion in limine to allow experts celebrate demonstration. That's interesting, and I think it's probably going to clarify, the forensic technology that was used between the first case and the second case. We talked about that a little bit before, but there's the Commonwealth's motion in limine to allow that. Also, I found interesting Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations, sustained findings unrelated to this case, or unfounded allegations of misconduct. Don't you find that interesting that they didn't even mention the name of Michael Proctor in the motion? But what else could this be about?
Oh my God. Well, even just seeing it, I'm like cringing in my skin. It's like, how are you going to say motion in limine to prohibit reference to any pending internal affairs? What do you mean? This is all about internal affairs. That's the whole problem.
Because they did look into a couple of other officers. Remember, they gave them slaps on the fist or took, 3 to 5 days away.
Go on vacation.
Yeah. Suspended with pay. I wish somebody would suspend me with pay. I think that'd be great.
I'll take it.
So the Commonwealth does not want any reference to what's going on with Michael Proctor in the pending internal affairs investigation by the I guess your dog came back from the vet and he's happy.
I was like, I'm hoping that the mic's not picking it up. Sorry.
That's all right. And then there's also right below it the Commonwealth's motion in limine to preclude the defendant from raising a third-party culprit defense. So, I just found that. And bear in mind, the defense will have time to respond to all of this. Then also on March 11th, the Commonwealth's motion in limine to allow counsel to state grounds for objections to promote judicial economy and efficiency and to adequately preserve issues. I don't know if you remember in the first trial, Judge Canoni had ordered the parties solely to object. She did not want the substance or the grounds for the objections stated in open court. She felt that it would be prejudicial to the jury, and she would allow or disallow the objections. And if it was something that she deemed worth arguing, all those arguments were done over at the sidebar. Remember all the sidebars?
Mm-hmm. Yeah, all the sidebars. We can't remember all the sidebars because it's seemingly so many that we don't know what happened during them.
No, of course not. And so the Commonwealth itself, I would have thought the defense would make a motion, but the Commonwealth itself is asking that counsel should state grounds for objections. Now, you don't argue it. You just say objection hearsay or objection best evidence rule or objection, and then you just use one or two words. But so that's what the Commonwealth wants to do. Affidavit of counsel in support of defendant's motion in limine to allow counsel to state grounds for objections. So that's interesting. Commonwealth's motion to allow counsel to state grounds, and then affidavit of counsel in support of defendant's motion in limine to allow counsel to state grounds for objections. Interesting. One of the last ones I found really interesting is defendant's motion to impound the defendant's motion in limine to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact.
Mm.
I found that really interesting, and we can come back to this issue of the alleged jury tampering, allegedly by Lieutenant Banning. The judge was rather injudicious, I would say, towards Alan Jackson, defense attorney, as he was making that argument. And one of the allegations, at least, was, Lieutenant Fanning works out of the Norfolk District Attorney's office, and there was an allegation that he had something to do with a pro-Reed juror being bounced. Now, again, I have more on that later on if we have time, and remind me. But I just found that really interesting. I'll bet this is not going to be allowed. But defendant's motion to impound the defendant's motion in limine to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror conduct, and that would be Lieutenant Fanning and Michael Morrissey. So go ahead.
I have a question with the impound. What are they trying to do with that? They're trying to kind of get it off the docket almost.
Yeah, they don't want it to be public.
Mm-hmm.
They want everything to be secret. Here's the defendant trying to keep it secret. With particular reference to this one motion, I can only imagine that it relates back to Special Prosecutor Hank Brennan saying, well, they said all of this in open court and they're tainting the jury pool. Well, Mr. Brennan actually had to apologize and file an actual apology or a correction in the record, he said. And that was a couple of days before March 11th. So that's not in this list. That was another thing. But so that's, I think they're trying, the defense is to avoid any more ire from the special prosecutor saying, oh, they're tainting the jury pool, because this is a serious issue, whether the judge wants to admit it or not. If the people at the Norfolk District Attorney's Office and a state police officer who's in charge of security for the whole case had anything to do with removing a juror, that is not inconsequential. That is not inconsequential. That's a big Magilla in my book. So that's amazing. I mean, before a trial, there's a lot of work to do. There are a lot of filings, a lot of motions. You don't want to PO the judge by bringing stuff up during the trial. You want to get as many evidentiary issues taken care of pre-trial. But then again, you also don't want to PO the judge by filing 41 things in one day. So it's a delicate balance.
Yeah, it's just that's such an I imagine doing 41 anything in a day.
I know.
It's I would do a call service and the calls would be 20 minutes and I couldn't even do 40 of those in a day.
Well, I can only guess, the defense, these are big law firms. Alan Jackson works at a big law firm out in Los Angeles, and David Yannetti has a staff and other attorneys that work with him in Boston. And I don't know to what extent Mark Betterow, who's been bounced out of the case, not even allowed in, I don't know to what extent he may or may not have helped. And Elizabeth Little, of course, we've seen that she's had even though she has taken a lesser role in terms of arguments in open court, we've seen that she's had a very important role behind the scenes in coordinating all the discovery, which is I can tell you as an attorney, a lot of people don't even know what discovery is, and we've talked about it a lot. Discovery is one of the main things you spend hours and hours and days on. But so anyhow, we had a lot of response from our viewers. And I think you said that we have 5 from the Reed case, and we're going to start with those. We have a check-in on the number of countries that are following our Reed coverage, and then we have another 5 on Coburger. So do you want to start out?
Yeah, of course. So Kira Saini says, I'm a little worried. Those pictures that are cleaned up of the taillight look a little more like taillight missing most of the plastic. That being said, how do we know that Proctor still doesn't have video? We still don't have the original 6-hour blocks of downloads, which most likely have missing 42 minutes. And something that I was thinking about the other day, Andrew, was
What's that?
this is like silly, and this is in our personal story category. The other day I accidentally sent Andrew an old video instead of the video I meant to send him for editing. So I just think it's funny that like I accidentally have old video and can accidentally pull old video, and this is video related to a case, and we're still trying to figure out where this giant 6-hour block, which is presumably a 12 gigabyte file, like how do these 12 gigabytes just disappear? I would love to get rid of 12 gigs.
Without the original or duplicate original with all the metadata, this case has no procedural excuse in light of due process and fairness to go to trial until that question is answered. Okay, so now we have Zoe Cove, I guess that would be. How come Judge Cannoni made each of the defense teams stand up like naughty children? I thought the same thing when I saw them all stand up and she questioned them all. How come Judge Cannoni made each of the defense teams stand up like naughty children and ask if they understood that they were a team and responsible for everyone else, yet the same was not asked of each of the prosecutors, reminding them the police and troopers et al. Are all part of their team, so they're each responsible for all of the actions of the prosecution team. And I would add law enforcement officers sitting in their office drinking lattes with thumb drives on their desk.
And well, even just that, it's just like they can't even do that because then they'll admit like how much of a mess everything is. It's just like if the prosecution was reminded that their whole case is based on evidence provided by the police, then we would be reminded of the fact that the officers in question were passing around folders with CDs and documents and moving this video around that nobody is able to figure out what was going on with it now. So as soon as you actually remind them of the case being built on the evidence that was provided from their team, the cops, it's a mess.
Yeah, Zoe, that is an excellent question. Excellent question. And thank you for that. Now we go to Hank's tattletale voice. Come on, somebody doesn't really have that name. Hank doesn't get to scream fact without providing evidence proving his statement. Hank, I hate to use this word, but we've seen it time and time again. So,
So we have this comment from John Harmon Day. Dr. Russell is viewed by the court as less qualified than a dog behaviorist. Good point. Dr. Russell had to testify for 2 days about her qualifications. The judge told the courtroom that the decision to allow Dr. Russell was close in terms of testifying as the medical cause of death. I sincerely doubt a dog groomer testifying for the prosecution would be forced to answer as many questions as Dr. Russell.
Do you know what really has a lot of observers of this case really wondering, where is the fairness? Where is what really is going on in this case? Where is the judicial impartiality in this case? That was a really good point that person raised. I mean, let's take a look at the order with regard to Dr. Russell. Here's Judge Cannoni's memorandum of decision and order on the Commonwealth's motion to exclude the testimony on Dr. Marie Russell. And here's the decision and order on James Crosby, the Commonwealth's witness, both of them to testify on dog bite. Let's take a look at the difference between these two. I'm glad that viewer brought that up. With regard to allowing Dr. Marie Russell 2 days of hearings. Dr. Russell had to endure 2 days of hearings, and then reluctantly, in a multi-page decision, the judge applied a proper close call, she said, legal analysis. Now, a legal analysis includes what's the issue and what are the facts. All right. Here are the issues and what are the facts. Then the next step in the analysis always is, what is the rule of law? The rule of law is Daubert and Lanigan in Massachusetts. Now, here are the qualifications that must be established in order to allow an expert juror. 1, 2, 3, 4, 5. Okay, that's the rule of law. Now let's analyze it. Okay, so she goes through here, and we've been through this before. Okay, what's her scientific technique? What's her modus operandi? How did she look at this? So we've got the issue, the facts, the rules, and now the analysis. And then she comes up with a conclusion. But before she does, she goes, psst, psst, Hank, I know you were paying attention, but here's 4 weaknesses in her testimony. In ruling, the court recognizes that on cross-examination, Hank, here's some tips for you. The Commonwealth demonstrated, among other things, that Dr. Russell's expertise primarily concerns the treatment, not the identification of dog bites. 2, that her evaluation of the abrasions failed to so she's giving Mr. Brennan some tips. Here are the weaknesses. It was a close call. We'll allow Dr. Marie Russell to testify, but hey, Hank, here's some tips. Now, where do you see any of that? Where do you see the issues? Where do you see the rules? Where do you see the application of the facts to the law? And where do you see the conclusion? And where do you see the judge, as she did to Hank, giving the defense some tips on cross-examination? This is it.
Yeah, I was going to say the only thing I'm seeing is page 1 of 1. It's just like we had, like you said, that other one is a multi-page document, very clearly talking about all those different things. But meanwhile, that's such a fair point where it's just like here, he just has 1 page. Okay, let him in.
After hearing and review of the pleadings, the court finds that the Commonwealth has satisfied the foundational requirements of Daubert Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony, principles, and methods employed are reliable. The defendant's objection goes to the weight of the evidence, not its admissibility. And two of the things that are really outrageous and show, a lack of fairness and lack of impartiality and bias up on the bench in this case is that, there's no analysis. There's no, okay, I'm going to take what I heard and in the motion and apply it. Plus, Hank Brennan got an opportunity to essentially do a deposition of Marie Russell on the stand. He brought his motion. The bench determined that, yes, we're going to bring her into court. So he had the opportunity not only to observe how defense attorney Alisi went through everything very methodically, but then he got a shot at her. Hank Brennan got the chance to stand up at the podium and cross-examine her and learn how she responds to questions. And something really important for trial attorneys, he got to figure out what the rhythm of questionings was going to be. And so he got a massive, massive, massive advantage in all of this. Whereas when the defense attorney said, hey, wait a minute, we feel that James Crosby, the prosecution's dog bite expert, should also be subjected to the same attention, they didn't get the opportunity to do the same thing. So if that's not clear bias,
All I would want to see is like at least an attempt to make a similar analysis or some type of anything versus just he's good, let him go in.
I must say I've never seen anything like this. It's very noteworthy, as people have given me a hard time for. I've tried to remain as impartial and as objective as I can. But just objectively looking at the two things, one motion has the traditional standard legal analysis. What's the issue? What's the facts? What's the rule of law? Let's analyze, apply the law to the facts, and come up with a conclusion. That's in one of the motions. And the other motion is just like, yeah, okay. And
sure.
One more thing. I hate when people say one more thing, but one more thing. Perhaps the bench was not impressed, but Attorney Alisi, the defense attorney, had pointed out that the bench had said you cannot establish or talk about causation without a medical doctor. Well, Marie Russell's a medical doctor and Dr. Crosby has PhDs, but he's not a medical doctor. So that goes to admissibility as opposed to credibility. In my mind, I'm not on the bench, but anyhow.
But even just like that, where it's
Yeah.
like she's like the fact that she doesn't address that it directly contradicts a previous statement, and it was pointed out to her by the defense already that she made that statement and that he was not fitting that criteria that she put. So the fact that she doesn't mention it at all is a little weird.
Yeah, weird's one word for it. So let's go back to our comments. And thank you, John Harmon, for that. That was a very good question. And the final remark that we have on the Reed case is Kate Dance. Writing on sticky notes, leaving it on desks. Where's the chain of custody log? What videos are laying dormant? Oh, yeah. Remember Hank Brennan had said that there were videos that laid dormant.
Girl, I can't handle it. And like the chain of custody log, and like if we had like, I wouldn't think anything of the chain of custody log because unless we had like better on, because the way that he described it being like so particular in New York really puts into perspective the actual situation here.
Yeah, you know what? I have a drawer full of these thumb drives. I've used them for years to back up, Christmas season pictures of the dog going through training, pictures of a vacation, pictures of taking the kids over to the amusement park, and I save them all on thumb drives. But I mean, they're in a drawer. So I'm just wondering what else Proctor and Lally and Fanning and Tully. I wonder what else they have laying around in drawers. I mean, I don't see why not send out a warrant to find out what's in their drawers.
Well, even I was gonna say like that picture, the what's in their drawers is a perfect tie into what I was thinking, because it's just like we have like Commonwealth versus Reed Sallyport like copy is just like, oh, there were 2 thumb drives, but I accidentally knocked one onto the floor. Like that's just what I imagine.
Oh yeah, and one night I had nothing better to do, and I might have had a couple of adult beverages, and I pulled one out and kind of edited it. Oh, oops, 47 minutes are missing. I don't know what happened. I don't know. So
I left it right there.
We now have 52 countries. No new ones since the last episode, but we now have 52 countries that have noted that they're watching the Reed coverage, and they've actually they're not just like sitting back and passively watching. They're actively viewing and then commenting, and so we have had comments from viewers in 52 countries. So I'd like to see it get up to 60, but that's me. Chile, Angola, Djibouti, and Kazakhstan are the most recent ones. We seem to have a bunch of viewers in New Zealand and Australia, and also England, Scotland, Ireland, and those countries. Wales. How could I forget Wales? Save the whales.
I'm curious. You mentioned we have a lot of people in New Zealand, and I've seen the New Zealanders commenting. I'm curious what you guys are doing with your day-to-day lives, because I have a friend that plays games and they're really good. They were like, yeah, because there was only 4 of us in all of New Zealand playing. So I don't know how dense it is over there or whatever, but I'm curious what your guys' day-to-day lives are, how populated.
That's interesting. One of our New Zealand commenters commented and reminded me that they are now going into their winter. We are going into here in the Northern Hemisphere, we are going into our spring and summer, at least in my mind, our happiest seasons, and they're going down into their fall. And I always forget that that's what happens. But
I'm about to be locked down and hunkered for the winter. So now going into our Coburger comments, we have Lizzie Ann 904. That 911 call poses some huge red flags to me. The kids were outside and allegedly thought someone was passed out from being drunk, won't wake up. Why weren't they with the person, shaking, trying to wake them up? Answer, because they all saw the blood, they knew 4 people had been murdered, didn't want to go near them, and never mentioned that to the 911 call tech. They never mentioned the other three. There's just something horribly wrong here. They deliberately withheld the info in the call. BF and DM knew something went horribly down by 4:30 a.m. and never did a damn thing. And I think another point that connects to that too, where it's like, oh, I texted them all and they didn't, like, nobody's replying to me, or I'm calling them all and they're not replying, versus like, oh, there's just one person here, is a little stand out to me. I think that's a really good point from Lizzie.
I think a really good point that she made and some others have made is, why are you telling 911 that they're unconscious? What about all the blood? What about all the blood that had to be all over the place from what we've heard before about this case? It's one more thing that makes you scratch your head and saying something doesn't line up in this case. And people have questioned whether the transcript that we got from the 911 call was even accurate. The texts, if you read them, they're a mishmash. Some are from 2 a.m, some are from 4:27 a.m, and then they jump ahead to 10:30 a.m. No, that's not credible, Idaho. Where's the whole thing? I mean, that was what we saw was just an exhibit that was attached to a motion. So I do have to remind our viewers that that's all we've seen so far is an exhibit that was cherry picked. There had to have been more texts. There's a whole array of texts, not just the little ones, the dribs and drabs, to grab a comment from a different case we're following. So I don't buy that what they said makes any sense, and I don't buy that we've seen them all. So then we go to comment number 4. Cyber Clue Crew. In my opinion, the 911 call was deliberately planned to confuse the... Oh, we have a conspiracy. There's so many conspiracy theorists around this case. The 911 call was deliberately planned to confuse the situation and to cover the 2 roommates' involvement. Note, too, that it never says who called 911, only that Bethany's phone was used, and the phone kept being passed around purposely. Why does Dylan only want to tell her story to dispatch rather than offer what was happening at the moment? Where's all the typical 911 comments like, what's taking so long? Good point. Good point.
The passing the phone around is a good point. And, obviously you mentioned this is a conspiracy theory, so this is just someone's comment. This isn't something that we're actually saying. But with the phone being passed around, I understand that the thing is, okay, I was going to say I understand in this moment of panic that there's like some hysteria and like theoretically people have been killed, so that's why they're panicking and passing the phone around. But why are they panicking and passing the phone around if it's just one drunk person? Actually, it's like, my friend's wasted, send an ambulance. Like, no, why are you, like, I understand that you might, like, the thing is, no, because I understand that you might be worked up and that it might be a stressful situation, but if you think your friend is just drunk, then it's not that stressful. Like, it's scary when you see your friend not waking up, and I understand that. But if you think it was just alcohol induced, and I don't know, like,
a lot of things
they
about
knew
this
they were
case.
dead. Yeah.
A lot of things about this case make no sense. It just makes no sense. It doesn't line up. It's just, if the facts don't fit, you must acquit. Okay, let's see. Number 3.
Falco Cyrus 8620. It depends on how you define the frozen shock phase. If Brian walks past her at 4:17 and startled her into fear and she's frozen for a couple of minutes before phoning around the house, that's the frozen shock phase, and it may have seemed longer to her because she was afraid. And then Kylie at the Ivy says doesn't last 8 hours, and in that time she calls every man and his dog but 911. And I I appreciate that comment, Kylie. But then that's, I think, a big discussion that's happening back and forth with these new details with the 911 call and with the text, is that because I think a lot of people's perception of it was like that she woke up, heard something in the night, thought like, that's weird, someone's playing with the dog, fell asleep, woke up, and then I'm like calling 911 after I fell asleep for 8 hours or something. But now we have a very clear picture that she was up at 4 o'clock and then she was up at 10 and they're calling 911 and whenever. Yeah,
I had one comment to really blast us, really blast me for, don't question these young girls. Until you've been in a traumatic situation, you can't judge. And do not even comment about this until you've been in a traumatic situation. Until then, don't even say anything. Well, guess what? If 90% of our commenters question this whole thing and question the phony frozen shock phase, do you think all 12 jurors are going to go along? Oh, these poor 20-year-old girls, we can't judge them because, yes, the jury's job is to judge, and that's going to happen. And you can't disqualify people from commenting because, and I'm sorry, you've had a horrible, traumatic, regrettable situation. A lot of us have, but you can't say don't judge. You can't say to people don't judge because, yes, Judgment Day. And I don't want to get into religion. I'm just saying in this case, based on the facts and the law, yes, Judgment Day is coming.
Well, I also like you mentioned that the person's just like, oh, well, you haven't been in a traumatic situation that you know. And it's like, meanwhile, your whole job is listening to people who are upset and filing for bankruptcy or got into a criminal case. And you're just listening to, like, here we are at the podcast just talking about traumatic stuff all day long. And I know people have a hard time. Some people may struggle with our using humor to cope with some of the horrible things they're reading about. But Andrew is really well versed in traumatic things. Andrew has done criminal cases. He has civil cases. Every day someone's coming into his office like, oh my God, Andrew, the world is ending, and he has to work with this person who's having a meltdown, like presumably. But also like, and another argument against that, it's like, oh, well, you haven't been in a traumatic situation. You don't know. What we have, the information that was provided to us, newly provided to us, that they released to the public, if we are to believe what they're saying themselves with the 911 call, they didn't even know someone was dead. So what are you going to be in a frozen shock phase when you think someone's just wasted on the floor? Like, yeah, that's scary. You don't want your friend to be like, needing hospitalization. But if you thought your friend was just drunk, maybe you can be distressed by that. But the frozen shock doesn't fit in with that, in my personal opinion.
No, it doesn't. No. Number 2, Stacy 8890 on other channel. There's other channels? Really?
What?
There's other channels?
What?
On other channels, they are giving Dylan and Bethany way too much of a free pass, possibly traumatized. Yes, possibly knew something was going to happen. A big yes. In my opinion, absolutely no excuse to not call 911 or climb out of Bethany's window if they were truly that terrified. Instead, they fell asleep. And yeah, I hadn't even thought of that possibility, but Bethany was on the first floor. Bethany was on the first floor that faced that, I'm not going to say parking lot, but the parking spaces in front, the millions and millions and millions of times we've seen pictures of that property. So yeah, if they were afraid, they could have. So I've heard other people saying, oh, this absolves these two.
Yeah.
Does it? I'm not saying that they're guilty. I'm not one of those conspiracy theorists, but I'm not saying this absolves them either. I said it before. I've got to say it again that, the real facts in this case are sealed, redacted, kept under wraps, a part of a non-dissemination order, gag order. So, until we hear more, I really don't know, but I'm just saying the whole thing, the pieces that we have don't fit together.
And I'm going off on another personal tangent, and I would tease about the people who hate it, but I know a lot of people have been commenting that they love it, so thank you guys. But it just actually made me think about recently, I have a friend who their kid is a college student, and their kid, a sweet little perfect angel who's never gotten into trouble in their life, recently their roommate walked in, and my friend's kid was passed out on the floor wasted after falling off their top bunk bed, and that student that walked in on that, their roommate, went and immediately got help.
Yeah,
so
of course.
And that's not, obviously everyone experiences things different, but these are 18-year-olds, like 17, 18-year-olds, and it's just two, like it's just 1 and 2, and it was able to be resolved.
Oh, there have been all kinds of stories since this case came to the public eye in November of 2022. Then all kinds of cases of children, 4 years old, 5 years old, 6 years old, 12 years old, seeing a horrible, horrible, traumatic attack on a parent or some other traumatic event, and they don't even think about it. They call 911. It's an immediate response. It's like a present sense impression or an excited utterance, like we talked about in a previous episode. It's just a reflex. You don't even think about it. You see something horrible and you do it. So anyhow, our last comment is right here.
Yeah, so Sans, and I don't know if that's an Undertale reference, but if it is, that's cute. Sans 7820. I know it's frowned upon to question the survivors, but they're incredibly suspicious to me. It doesn't make any sense that they were awake, aware, and freaked out when they chose to simply go back to bed and wait 8 hours to have other people come over and call 911 saying that one of them is unconscious. People make up excuses for them, but something is fishy. And that kind of goes back to the theme of these comments, which is, what the heck?
Yeah, just something is fishy. Something is fishy. That's the best thing to say about this. It's just, I don't know. I guess we've beat a dead horse on this one, but it's just so many people have commented that when people tell me don't judge, I'm like, but the vast majority of our commenters say similar things about this, that, you know what? No, it makes no sense. So.
And I know, like, the experience, like, especially as my own personal experience being a woman and needing to be scared, I understand that people handle anxiety and handle stressful situations very differently. And, some people do have panicked reactions, and some people are like, take the phone, I can't handle this type people. So we don't want to say, like, we're reading the comments here. We're not saying, like, oh, they're lying. We're not saying, oh, they're telling the truth. We're saying that people have questions, and there could be reasons, but they just gave us a lot more information that the public was already really, like, confused about this situation, and they gave more information that led to more confusion, and this is the result of that.
Yep, it sure is. And so we have to conclude our comments section of this podcast, remembering that the case is all about the Idaho 4, the 4 young victims of this horrible crime that occurred in November of 2022. Kaylee Gonsalves, Madison Mogan, Ethan Chapin, and Xana Kernodle, their families, have suffered a terrible loss, and they're waiting for justice, whatever that means. And so we just, we have to remember that in every episode. So let's switch back to Reed. Just one last thing I have to get in. And I just, going back, we did in a previous episode, we covered the hearing that occurred on March 5th, the motions hearing, and they were talking about the motion to dismiss for extraordinary government misconduct. And I'm thinking, as I'm rewatching part of it, because we throw these out. All right, I'll speak for myself. I throw these episodes together so quickly because I got a lot of other stuff going on in my practice and my life. That's why I can't do these 2 and 3 hour deals. So I had to go back and it's just I'm kind of hesitating to talk about this, but it's just so obvious the bias on the bench in this case. The issue was whether or not allegedly Lieutenant John Fanning, who was the supervisor of the overall security from his workplace at the Norfolk County District Attorney's Office down in Canton, whether he had anything at all to do with the removal of a juror who had apparently seemed to be very pro-Reed. In any event, that juror was removed, and as they certainly were wont to do under their duty of due diligence, they made that as one of the issues in the motion to dismiss for extraordinary government misconduct. Well, the bench is supposed to let the attorneys argue. The bench is supposed to be impartial and removed and allow the parties to make their arguments and then go in the chambers and issue their decision. But that isn't what happened here. Take a look at this and tell me if you're as offended by this as I have been.
State as fact that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have
Are you going to let him argue it or just tell him it's not true?
any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that, and I'd like you to start there.
If the court recalls the discussion at sidebar, we were told the name Lieutenant Fanning. We obviously
You were not,
recognized
just
that.
so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. I believe the court then inquired of one of the court officers.
Who
court
are in
officer-
charge of the jury?
During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required. Period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says.
But wait a minute. Hold on. If Lieutenant Fanning is in the district attorney's office, and we know they were watching this trial closely, okay, they were in Canton and the trial was up in Dedham. I don't know how many miles it is, 20, 25, 30 miles. I don't know. It's been a long time since I drove back and forth there. Who's to say he doesn't have the ability to text, phone, use the private, frequencies that they use? And the point I'm trying to make here is Hank Brennan has certainly shown his ability to argue a case, pound on the podium, be aggressive. And isn't it Hank Brennan's job to make these arguments? If you're making your argument as a defense attorney, do you expect a judge to be arguing with you? No.
Not only that, but I also, why does the juror know who this is? If I was in the situation, if I were a juror, I'd be confused by every new person I meet. You go into a new situation, it's just like you're all meeting all these faces. It sounds like they know of this person, so why does the juror know of this person?
Well, the defense had actually asked the court to make an inquiry, and that would answer your question and others, but the court denied that request.
And I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer,
She loves to get in digs against Alan Jackson that he's not a Massachusetts attorney. He's from California. She loves to get those digs in.
knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors.
You were told that at sidebar
No.
that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth.
I will let you move on. I can tell you I'm really not satisfied with your answer, Mr. Jackson.
Your Honor,
Now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Is
now
there
that you
evidence
know
that-
it's not true.
is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect?
We will move on from that, Mr. Jackson. What you
What-
state is fact that Lieutenant Fanning had control.
What an amazing attorney to stand up to that. I think a lot of attorneys would have backed off. I think a lot of attorneys would have changed the subject. I think a lot of attorneys would have used different words. But what an attorney Alan Jackson is to stand up to that. And remember that there have been hints that the judge wants to revoke his pro hoc vice status. So I don't want to say a whole lot more about it. But when I went back and viewed the hearing a second time to digest it fully, that stood out to me. I don't think I've seen a colloquy, or I should say a conversation back and forth like that ever. I just don't think I've seen it.
Well, I think you made a good point in complimenting like what a good attorney he is for like kind of sinking his feet down and going into that, because I'm like squirming in my chair just listening to her go. I'm like, oh my God, I don't want to be in that. I don't want to be him right now. Like that was brutal. She really dug into him.
I mean, just because Lieutenant Fanning was in Canton and the jury was up in Dedham, it doesn't. Lack of access, access can be a lot of things. Can I go over and open that closet door and have access to the closet? Yes. Can I call someone down that I know in Pennsylvania and ask them to access some video that I know is on a computer down there? Yeah. So what's the definition of access? I mean, they're both access.
That is exactly where my mind was going, because like he might not have had direct access, but she was saying like, oh, only the officers had, like only the court officers have like access to the jury, but he has access to them. He has access to the people making the court officers, the people marshaling the jury. So even though like he may not have had direct access, that doesn't mean that he might not have had information or just any other knowledge. So I'm not in this court. I don't know what's happening in their sidebars and what kind of arguments are happening, or who knew what at what point, but that was a little mean.
Yeah. So we did point out in the last episode, and I have to bring it up again here before we say goodbye to everybody. I have to bring it up that they're two different departments totally. The state police are one branch of government, and the court officers that you see walking back and forth with their white shirts and their ties on, totally different. And the court officers, as has been pointed out, are above reproach. They have a job to do, and the many times I've been in court, you have total respect for them. But that's not to say that people don't talk. That's not to say there wasn't a communication from one to the other. We don't know. I don't know. I wasn't there. I wasn't at the sidebars. I wasn't in court. I've never talked to Lieutenant Fanning. I've never talked to any of the court officers in that court. It's been a long time since I've been in that court. I haven't talked to anybody. It just seemed that video clip shows something.
Well,
that video clip shows something. It just does.
After what happened with Proctor, I would love to see Lieutenant Fanning's phone. Like, if it's not gonna happen, but it makes me curious, the situation. If that was going on with Proctor, maybe Fanning didn't have access to the jury. Maybe he's innocent and maybe his phone is totally fine. But like, if Proctor was saying all those things and now they're getting this other guy involved, I don't know if they would be trying to get him involved if they didn't have reason, because they wouldn't be fighting to get him involved in the court and getting this whole situation brought up if it was going to make them look like a disaster, if nothing was up, in my opinion. Every attorney's going to have their own strategy and stuff, but why fight for something that you don't think you can prove is kind of my thought.
Right. And I'd like to know what our viewers think, especially since I showed only the docket and the titles of all the documents that have been filed just in one day in the Karen Reed case. So if there's any particular document or any particular allegation or fact or law or aspect about this case you'd like us to dig into, let us know, because you know what, there's no way between this second right now and when we do our next episode, I'm going to have time or ability to read all 41 of those documents. There's motions, there's affidavits, there's all kinds of stuff. And so let us know down in the comment area if you would like to have us focus on a particular area. Don't forget to subscribe. I put a new little thing down in the lower right-hand corner, a new little widget. You can click on that and subscribe. So we're still in the 13,000s, Lainey, for subscribers. We still have, before we started this episode, we had 13,900 and some odd subscribers. And I'm very superstitious. We have to get out of the 13s and get up to the 14s. So subscribe. I'm not begging anybody, but I'm begging everybody.
Yeah, we don't want your money. We just want, if you like this channel and want to support this channel, subscribe. And if you don't feel like subscribing, somebody was just like, I'm not going to subscribe to you. Da, 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 da. You don't have to subscribe either. You made it to the end. Like, you don't have to subscribe. We're not going to tell you how you live your life. You can keep watching, but if you like us, consider it.
Yeah. Did you have a special little emoji you wanted people? We got a lot of suns. Last time you asked people if they made it to the end of the episode to leave a sun, and we got a whole bunch of suns. So do you have a special emoji that we haven't used yet?
I don't know about if we haven't used yet, but Zuko, come here.
Oh boy, here we go. My dog Lily's home. She's
Well,
home.
if comment the dog emoji for all the barking that was going on earlier in the stream, if you made it this far, to prove that you're paying attention. He's not happy. He just got shots. I'm bothering him right now, and he's like, Mom, my leg hurts. But
Yeah, dog, you have to learn how to be quiet. You're in a studio here. You have to learn how to be quiet, dog.
You're in a law office, honey. You're going to be an attorney someday.
The hell with that.
Yeah, so comment your dog emojis down below. We appreciate you guys so much and are looking forward to hear what you say. You guys had some really good comments this week, so we appreciate that.
Have a good one until we see you in the next one.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.